Good afternoon, everybody, and welcome to our webinar this afternoon. My name is Ian O'Herlihy, and I'm head of the education team in Mason, Hayes and Curran. And I'd like to introduce my colleagues on our webinar this afternoon, Paul Rochford, Edel Kennedy, Anya Haberlin, and of course, David Ruddy, who will be well known to many of you already. Today's webinar is on the child protection procedures for primary schools, and we're asking the question, are they effective? And we largely think that they are, but there's a little few bumps in the road, as we say, when we're looking at how the procedures work. So we're going to be examining those as we go through. Just before I proceed, I'd just like to say a word of thank you to our friends in CPSI and IPPN for their support with today's webinar. So a quick word on what I suppose we're going to do today and what we're not going to do. What we're going to do today is look at, obviously, at the child protection procedures, look at, Children First Act and how these things impact on statutory obligations. We're going to look at obligations on schools, keeping students safe and risk assessments. But what we're not going to do is we're not attempting in, say, 40 or 50 minutes to present a comprehensive summary of all of these child protection procedures, because as many of you will know, there's legislation, there's the Children's First Act, there's the previous large book called Children First, and there are the child safeguarding procedures, which we're going to discuss, which run to about 100 pages. So you'll understand that it's not possible to do any sort of a comprehensive run through. We are, however, going to look at what is coming in our door, the kind of things that we get asked to advise upon. And I'm going to be looking at the various issues today with my colleagues under two broad themes, I suppose. One is looking at the issues and concerns around child protection from outside the school. And the broad theme of that is that your really first port of call is TUSLA, because obviously your school doesn't have jurisdiction outside of the walls of the school. But we're also going to be taking some time to look at a very tricky area, which is child protection concerns and complaints against a member of staff. And we're going to look in particular at the child protection procedures and chapters 7 and 9, because these are the procedures that really deal with, complaints, concerns in relation to a staff member. Chapter 7, in our view, is very helpful. We consult it all the time. Chapter 9 is a sort of a more recently introduced issue around what is called oversight. And this is oversight of the role of the principal stroke DLP by the Board of Management. And we're going to be coming back and looking at that because there are certain particular issues that we want to bring to your attention. David.
Thank you, Ian, and good afternoon, everyone. We're going to ask you to help us take a snapshot, as it were, of where we stand in relation to actually the whole question of making a mandated report to TUSLA. So we're going to ask you to put a yes or no, give a yes or no answer as to whether you've ever forwarded such a report to TUSLA. Secondly, we want to ask you, and that would be for a DLP. The second piece would be in relation to the Board of Management. Have you as a board ever had to handle an allegation against a member of staff? Something we're going to talk about in some detail. And the final question then is in relation to what Ian alluded to in the last slide, the procedures. They're now 4 years in operation, and we're just curious to see, do you think these procedures work for your school? So at the moment, while we're waiting to get in the results, as it were, that are coming in thick and fast there, Ian, you just wanted to make a point, I think, there.
Yeah, well, just I suppose a comment in relation to question 2 there, and to say, I did say earlier on, this is a tricky area, and it's particularly tricky because it's really the situation where 2 fundamental obligations of a board of management of a school come potentially into conflict. I mean, obviously we all know the fundamental duty of a school is duty of care to students, and particularly around child protection. But boards also have a duty of care and a duty to be fair and to be supportive of a staff member, generally speaking. And the problem is that when a complaint like this comes in, these 2 issues can come into conflict, and it really, really can be a challenge. So that's something we try to explore as we go through these issues.
Thanks, Ian. And just to say a big thank you to Catherine Madden of her events team for organising this poll. Very interesting result, very much in the balance there. 51% having made a report, as opposed to 49% not having done so. We conducted a similar poll a few weeks ago for our post-primary colleagues, and the figure was much higher. I think it was roughly about 80% would have made a mandated report. In relation to the allegations against a member of staff, you can see there 16% have said they have had experience of doing so, whereas a whopping 84% have said no. And that would be sort of roughly in correlation with the post-primary sector also. And finally, a big 91%, whopping 91%, feel the procedures are working. That'll come to the relief of the Department of Education and Skills, certainly, and 9% no, which roughly is in line with the post-primary sector. Ian, you have a smile there. Are you content with the results, or any surprises there for you?
No, I suppose I would have expected, maybe, I don't know why I say this, but I kind of would have expected that the answer to number 2 would have been less in the primary sector than the secondary sector. But that's something that we can maybe reflect on and maybe give an opinion on later on.
Okay, thanks for that, Ian, and thank you for participating, everybody, in our poll. So we will move on, and the next piece we're moving on to concerns mandated persons. So I'm going to call in our partner, Paul Rochford. Good afternoon, Paul. How are you?
Good afternoon, David. I'm well, thanks. Good afternoon, everybody.
In relation, Paul, to this particular area, it has been said that the 2015 Act has been a game changer for schools, in that all teachers now are mandated, and people have spoken about burden sharing. So what's your take on this?
Yes, well, that is a change that was brought in by the 2015 Act. It set out in the schedule to the Act a list of what were termed as mandated persons who had a positive obligation under the legislation to do certain things in relation to child protection concerns. And one of the groups within that schedule was registered teachers. So they now have a statutory obligation, and as it's laid out there on the slide, the 2 primary obligations they have are to report any reasonable concerns of harm above a certain threshold to TUSLA, and secondly, to assist TUSLA then once that report has been made in any assessment of the concern reported. Now, typically in a practical sense, that happens in conjunction with the designated liaison person within the school, and typically either they or somebody else will have already reported the matter to the DLP. The DLP will have been in contact with TUSLA and will, if it meets the threshold, be making a report in any event, and they can make a joint report with the DLP, and that suffices to satisfy their obligation. But there may arise a situation where the DLP, for whatever reason, is not making a report. Maybe he or she has contacted TUSLA and has said, no, look, this doesn't meet the threshold. You don't have to report that concern to us. So individual teachers should be aware, and principals and board members should be aware. They still have an obligation to make their own decision in relation to that obligation as to whether or not they should still make a report, and they should, by rights, then advise the DLP what they're doing in relation to this. If they're going to make a report, they should probably let the DLP know that as well. So that's the additional obligation that's now been placed on them. They all have it, but there are other wider obligations. Somebody put a query into us recently in relation to special needs assistants and whether they were mandated persons. They're not, because they're not listed in the schedule to the Act. However, it's quite clear that all staff members within the school have an obligation to report matters of concern to the DLP. If they don't have an obligation to report directly to TUSLA, they still have an obligation to report to the DLP.
So Paul, I take it teamwork is very much part of the success of the procedures in schools. Oh,
I think it's vital. I think everybody has a role to play, and you know, as we'll repeat throughout this, the primary concern is keeping children within the care of schools safe, and everybody has a role to play in that.
Paul, the whole area of reasonable grounds for concern, you referenced that in the previous slide there. Can you drill down a bit more into this, please? Certainly. Well, so the procedures talk about you know, meeting a threshold and reasonable grounds for concern, and talk about these categories of abuse that are set out not only in the procedures, but they're set out in the Act, and 3 of the 4 that are on the screen, they're actually defined in the Act, and they're pretty clear and brief definitions, so they're easy to understand. The emotional abuse category is not defined in the Act. It is taken to be captured by the definition of ill treatment, which is set out in the Act, which talks about you know, cruelty or abandonment. That's contained within that definition. But that can sometimes pose difficulties in terms of dealing with that particular category, in terms of where you are on the threshold in terms of reporting to TUSLA or discussing those types of concerns with TUSLA. But I think the general view is that, look, where there is a risk to the child's health, welfare, development, either past, present, or future, that's when you're getting into the category of reasonable grounds for concern. Obviously, anything related to sexual abuse, that's a slightly different consideration, in that anything under that category would be considered as serious and would be dealt with accordingly. So I think it's important for people to understand what those various categories are, and to understand what they might be on the lookout for, or what might be fitting within their decision process in terms of any of those types of abuse that are set out in the procedures. Paul, notwithstanding what you said about emotional abuse not being defined, any child who has been neglected, physically abused or sexually abused would have suffered emotional abuse. Would you agree with that? I think it would probably fit in within that category, but that's the nature of this area of the school life, is that it's the observations of the day-to-day, which goes back to what we were talking about team effort and everybody playing a part. Some matters may be reported directly by a child or by somebody else from outside the school, but other matters may be picked up by observation by staff, by their teachers or otherwise. So it's part of the daily responsibility, I would say, of people with staff within the school to keep an eye on these things. Thanks for that, Paul, and we'll come back to you shortly. Next, I'm going to move on to Anya. Do you smell a good Anya? Hello, Anya. Okay, we're waiting on Anya here. I'll come back to her in a moment when we make contact with Anya. Sorry, Anya.
Hi, David. Kunastá Brona ran sin.
Carth Galore, Anya, Lanaraya and Shin. We're just go back to the whole area of the mandated person and that. Can you take us through their duties? Absolutely,
yeah. So mandated persons have 2 main legal obligations under the legislation, as Paul has already stated. So it's this double obligation. It's firstly to report harm of children above a defined threshold. So that's the defined harm threshold, which I'll be discussing later on, you know, the definitions of harm and kind of drilling down further into that. And then it's also to assist TUSLA, if requested, in assessing a concern which has been the subject of a mandated report. So as a mandated person, under legislation, you are required to report any knowledge belief or reasonable suspicion that a child is being harmed, has been harmed, or is at risk of being harmed. So it's quite broad. So I suppose what we're left with then is trying to kind of grapple with the definition of harm, and where it's not defined. There's certain concepts in the legislation that are not defined, and certain harms, as Paul says, that are not defined. So the Act defines harm as assault, ill treatment, neglect, or sexual abuse, and covers single and multiple instances. So again, a very broad scope. So I think, you know, to put the definition of harm into two categories. The first one is the assault, ill treatment, or neglect. And then the second one is the sexual abuse. For the assault, ill treatment, and neglect, the defined threshold of harm has to be met. And what I'd always recommend is get in contact with TUSLA in seeking to get advice around that and whether a defined threshold of harm is met. Always err on the side of caution there. The sexual abuse then is a separate type of harm, and there's no threshold here. So if there's ever a concern there, you know, a mandated report would have to be made. So I suppose just to give you kind of practical examples of where we've seen, you know, these definitions played out in real life, you know, for assault, for example, physical assault, it's definitely a more clear-cut, you know, example of harm. We had a case recently, and it was an allegation that a teacher dragged a student across the floor, and the SNA actually reported it to the DLP, to the principal, bearing in mind that an SNA is not a mandated person under the legislation, is not included in the schedule, but the SNA still had a general obligation under the guidance to report it. So all staff members have that general obligation. So the principal got advice from TUSLA there, and the matter was investigated. So like, that's an example of a very clear-cut scenario. Another example of a fairly clear-cut one was an allegation in relation to a parent. And this was brought to the attention of a class teacher. So going back to what Paul said earlier about a class teacher being, you know, in a good position in order to observe, you know, certain behaviors of children and stuff like that, you know, it's a very, you know, I suppose it carries an awful lot of responsibility, and that's why I suppose the procedures are good, you know, there as a support to the class teachers in knowing what to do when something like this confronts them. So this was an allegation in relation to a parent. It was during a weekend, you know, assault had occurred, allegedly occurred. So it was not in school hours, but the class teacher did report the concern to the principal, and a report was made to TUSLA, and it was investigated. So then oh yeah.
Go ahead, Anya, there. Yes, yeah, go ahead.
Yeah. So then moving on then to the ill treatment. And this is, you know, the kind of realm of emotional abuse. And it's one we do have a bit of difficulty with because there is no definition for it at the moment in the legislation. And it is quite subjective. You know, we've had instances where there's been allegations of emotional abuse made against a teacher, you know, where students were affected, maybe in, you know, it was physically, there was physical manifestations of that, you know, and that they weren't sleeping, not eating. So it is very serious, but it's just that obstacle of not having a definition. I think Edel had an interesting case in relation to this one.
Yes, Sonia, and good afternoon, everybody. I suppose for clarity purposes, whilst we have repeatedly spoken about there being an absence of a definition regarding emotional abuse, it's important to set out the fact that there is a definition within the child protection procedures themselves, just in case there's any ambiguity on that front. And it's 2.1.3 of the child protection procedures sets out the definition. There are some categories of emotional abuse. And in terms of our involvement in a High Court case, which was the Killaloo case in 2019 involving the dismissal of a principal for emotional abuse, in that case, the High Court found that the challenge to the finding of emotional abuse didn't stand because it came within the definition which was stated in the child protection procedures, that being the use of overly harsh disciplinary measures in respect of that child who was put on her knees facing a wall on 2 occasions by the principal. So it's important that whilst there is no definition within the Act itself, that the child protection procedures are very helpful in terms of paragraph 2.1.3, and also in terms of the information that they provide about how emotional abuse can manifest itself. So that's also provided for in the child protection procedures at 2.1.3, and it's very important that in reviewing any cases of emotional abuse, that those procedures and specifically those paragraphs are reviewed, because they are quite helpful.
Absolutely. Yeah, definitely. Those examples are definitely of assistance in bringing reports and for TUSLA. So then moving on to neglect, and this is I have an example of the child protection procedures working really well in this case. We had a case where a teacher picked up on a student that they thought might be suffering from neglect, and there was issues of alcoholism at home for the child, for the child's parents. And this was actually a good outcome, where the procedures actually worked favorably for the child, and the child was actually protected in the best way possible. So just to bear in mind, the procedures are there to help, and they do work well.
And Anya, can I just say, just in relation to primary schools, that neglect seemed to be the category with the largest amount of referrals. Would that surprise you?
No, actually, I think that would match up, because I suppose the class teacher would have, such good exposure to their class members, in that they'd see them day in, day out. Come back to what Paul was saying, like they're in that position that they'd be able to kind of observe all the different comings and goings of the students, so they'd definitely be able to pick up on little things. And I think that's really important thing for class teachers to be able to do it, and given their kind of legal position as a mandated person then in that regard.
Okay, thanks for that. Right, and you have down here that for sexual abuse that there is no threshold there. What do you mean by that?
So if there's any kind of reasonable suspicion of sexual abuse of a child, it just needs to be reported to TUSLA, and there's no need to kind of reach a defined threshold of harm. So there's no need to do that. So it just is reported straight away.
And Anya, then we'll move on to the role of the mandated person, and you've some further points to make.
Yeah, so this, I suppose what we would consider on a day-to-day basis is, sometimes anonymous complaints come in, and it is quite difficult to proceed on, an anonymous complaint. And the advice we always give, is to get advice from TUSLA when an anonymous complaint comes in. It might be through many different sources. Now, practically speaking, TUSLA may not be able to do anything on it because it is anonymous, and a staff member, has a right to know who is making the complaint and what is being said about them. That's procedures. So it might not ultimately be investigated, but it's really important to take a note for the DLP or a mandated person that, they have rang TUSLA and they've sought advice in this regard. So just keep that note, that even if it is an anonymous one, keep that note of having contacted TUSLA.
And Anya, Paul referred earlier on to the statutory obligations of a teacher. When they fall short of that in failing to report under Children First, what are the sanctions? So
there are no, as the slide says, there are no criminal sanctions, but nevertheless, it is quite serious, if a mandated person does not report. So the first thing is the complaint to the teaching council, so obviously there's many different, outcomes from that, but it is quite serious if it goes, all the way to an investigation and then possible revoking of licenses, registration. They report to National Vetting Bureau, that's another one. And I suppose the most common one that we would see would be disciplinary proceedings invoked by a board of management. Now, I know Ian will speak about this at length later on, So I'll leave that one to him. But yeah, so disciplinary proceedings are definitely probably the most common one that we would see.
Anya, thanks for that, and we'll come back to you shortly. Ian, so far we have alluded to the role of the mandated person and the non-mandated, as Paul said, special needs assistants, and of course the DLP. But the Board of Management have a big role too in all of this, haven't they?
Yeah, David, they do, which has been really sort of developed or codified in more recent times. Now, most of the people listening in this webinar are principals, and several hundred principals listening in, and the vast majority of them would be DLPs. Although that doesn't have to be the case. It doesn't have to be the case that the principal is a DLP, but very often that is the case. But the Board of Management has a role in this whole area as well, because I mean, obviously, to start with, the Board of Management is the employer of all staff in the school, the hirer and the firer. And Edel is going to be looking at just shortly at the whole issue of disciplining a member of staff in this whole area. But I think it is worthwhile, just one little sentence, it's worthwhile saying that, you know, not all concerns of abuse are what we might call gross, which would involve, you know, very serious disciplinary measures up at stage 4 disciplinary procedures. It may be that, you know, the manner of interaction of a teacher with a student is not good, and maybe it doesn't reach the threshold of that would be required to be, you know, abusive in the formal sense. But not, you know, it may be that that disciplinary action at a lesser level is required. Now, just to, I suppose, focus on the red bit in that slide, the Board of Management has an overarching oversight function for child protection and employment. And that's something that we're going to be I'm going to be focusing on if we go on to the next slide, because, well,
Your slide, Ian. This is your
first slide. That's David's elephant in the room. The elephant in the room is really the issue about, first of all, dealing with a complaint of abuse against a member of staff, coupled with the oversight obligations of a Board of Management. And if we go on to the next slide, you'll see that we have put down in that slide basically sets out the oversight, child protection oversight report of a Board of Management by a principal or a DLP. That, I said earlier on, is kind of dealt with in Chapter 9 of the Child Protection Procedures, which are in the history of this whole area are kind of relatively new. And I'm not going to go through all of this because principals will be very familiar with the oversight report because it comes up at Board of Management meetings, so you'll be familiar with all of this. But what I do want to just focus on for a moment is the section in blue. And I'm not going to read down through all of those sections, but this is basically what an oversight report needs to include where there's an allegation or concern of abuse made against a member of staff. I wanted in particular to look at blue, the B bit, and this is where advice has been sought from TUSLA by a DLP, and on their advice, a report, TUSLA have advised a report to TUSLA is not required. And the reason why we're raising this is that a couple of us on the team have had fairly recent situations. One I had only a couple of months ago, where a principal DLP was notified of a child protection concern, did her own sort of just preliminary inquiry about it, was not convinced that there was anything there, but out of quite correct caution, reported the matter to and sought advice from TUSLA. TUSLA reviewed the matter and decided that there was nothing to report to them. They had no particular concerns. So we had a situation where the principal stroke DLP didn't have a concern, having reviewed the matter. TUSLA didn't have a concern, but according to B there, that matter had to be reported to a board of management meeting, and more particularly, the teacher had to be named. Now we have a major issue with this because we just think that it is a dangerous provision. For so long as I and the team have been dealing with child protection matters, we have told, first of all, ourselves, but also schools, that child protection matters need to be dealt with on a very strict need-to-know basis. And in this sort of situation that I've just outlined, we have major concerns that is there a need for 8 members of a board to know the name of a teacher where an issue has arisen, the principal has no concerns, and TUSLA have no concerns. So we just think this is a major problem. And you know, we're aware that these procedures are coming up presently for review, and our hope is that this will be something that will be looked at, because you know, we have major concerns.
Ian, this particular point, I think, will resonate very much with management bodies, principals associations, and indeed the unions, because when the department were drafting the guidelines as part of the consultation process, this issue was brought up. And despite the opposition from all the partners, the department were adamant that this would go through. So it's very interesting that 4 years on, you have noted that, and that's your viewpoint is shared by all members of the team. Moving on to the next piece here, and this is the issue of compliance again, and what Ian alluded to there in the last slide. The department have invested a lot of time in the procedures, but equally they have an inspectorate role in relation to child protection, and this was foisted upon them by TUSLA and indeed the Ombudsperson for children. And so the department had to take the running up on this. And as you can see, they have 3 levels. And at the very basic level, you have 3 checks, which would be something as straightforward as looking for the child safeguarding statement to see that it's published, that it's signed by the board of management, etc. At level 2, where you'd have a whole school evaluation, which would take place over a number of days, you have 5 further compulsory checks to add on top of the 3 initial checks. And then finally, at level 3, which is the dedicated child protection schools inspection, this will take place typically over 2 school days, and it will have 10 checks and up to 65 sub-checks. And the results are published in a report. And I don't have to tell you, but from a reputational point of view, it's really important that schools, well, get good reports in every evaluation, but particularly in relation to child protection. So just to move on further in relation to these reports, as of now...
David, sorry, just to interject there, just to pick up your last point on the publication of the report and go back to what Ian said on the last slide. Just to kind of clarify it for people, I take it that means that if you choose to follow what we're suggesting might be the prudent course and not name a teacher where there's no concern and that has been checked with TUSLA, and you've done that might be picked up by an inspection and that might feature in a report subsequently that you haven't done that.
Paul, it's not that it might, it will almost be picked up. They will go through the reports and one will get a not compliant. And even when they do the second visit, I don't know where you're, but by and large with these reports, and they're worth having a look or a read at. I think every school should do so. Mostly what happens is the school will be partially or substantially compliant in an area, and on the second visit, they can up it to fully compliant. If you don't have recorded exactly that you made a report to TUSLA, you made an inquiry to TUSLA and they didn't require a mandated report, it's very hard to know how you're going to get from not compliant at that stage when the records aren't in place. So absolutely. So we have to stick we have to hold our nose, as it were, if we don't agree with them, and get through it until.
Could I interject there and just that point
Yes,
as
Edel.
well, David? That's
Yes.
my experience of it, is that schools will get the black mark, as in, you know, by the inspectorate, they are not compliant with the child protection procedures if they don't. A way around it, or just a suggestion that I had for a client, was that in a situation where an allegation against a member of staff was subsequently withdrawn following the matter being reported to the Board of Management, what the principal asked me was, could she go before the board and advise them of the fact that the matter had been withdrawn, you know? And I said I saw absolutely no difficulty with that, but just to say it to the employee that that's what she proposed doing, because in her mind, that was the fair and right thing to do in circumstances where they've been notified of the allegation in the first instance.
And Edel, yes, I mean, what could happen there also, that could be filed away. So when the inspectorate did look at it, they would see, well, look, has been a sequel to this. So I think that's a very good point, and thanks for clarifying that. So without going into any more detail on this, there is a circular 72/2020 that deals with this, and there's an excellent PDF guidance in relation to it also. So we're going to move on to the question, and this is Edel, where I'm going to bring you in on this, where you get the phone call from the chairperson of the Board of Management, RDLP, and they're asking for advice. Obviously something serious has emerged, and as they say, there's a fork in the road with the procedures. Edel, I'll pass it on to you, please.
Yes, okay, David, thanks. Yeah, so when we're talking about two separate procedures here in terms of managing employee child protection suspicions or allegations, what we mean is, first, there's the reporting procedure. So that's everything that's been discussed up to now in the main in terms of the mandated persons and in terms of the DLP complying with the obligations under the child protection procedures. That's part one. And then part two, if you like, is how the school or how the Board of Management deals with the employee vis-a-vis their employment with the school. So that is the procedure that's to be followed by the school in terms of addressing that issue from an employment perspective. So when we were talking earlier about, you know, there not being a definition of emotional abuse under the legislation, I suppose just to say that that is relevant in terms of the mandated report and the report being made by TUSLA, part one of the procedure. But part two, let's say, for instance, let's take a scenario whereby we have contacted TUSLA in respect of an allegation of emotional abuse against a member of staff, and TUSLA say that they don't see that there's any requirement for assessment by TUSLA. So then it falls back to the second procedure, that is dealing with the matter vis-a-vis the employee's employment with the school, and that is specifically an investigation by the school of the allegation of emotional abuse. And that's when the procedures and the specific definition that I outlined earlier comes into play for a school, a principal or a board who's dealing with this issue. And I suppose it's the DLP firstly in terms of the reporting, and if indeed the DLP is the subject of allegations, then it's the board or the chairperson who's responsible for making that referral or making that contact with TUSLA to inquire as to whether or not a referral is made or should be made. And if the DLP or the Board of Management member is the subject of those allegations, then the patron must be informed in that situation. And in terms of next steps then involving the allegations, what's invoked is the protocol authorizing immediate action. And as Ian said earlier, you know, we open these procedures every time there's a new issue involving child protection procedures, and specifically Section 7 of the procedures is very prescriptive in terms of what has to be done by a school in this situation. And Appendix 3 here is instructive. So what has to happen here by virtue of the protocol authorizing immediate action is this. So once the school becomes aware of it, and if TUSLA come back and they say yay or nay in terms of a referral being made, let's say they say no need for a referral, and the school deems that this matter needs to be dealt with under the protocol. So it's the chairperson then who considers whether or not the protocol needs to be initiated. So the chairperson is authorised by the school management to direct the employee to immediately absent themselves from schools without any loss of pay. That's if the chairperson determines that that's necessary. And the Section 7 gives instruction on and the procedures themselves on how and in what way that decision might be arrived at. Specifically, the priority being to ensure that no child is exposed to unnecessary risk. That has to be the guiding principle here in terms of a chairperson's decision on that front. And it's important to bear in mind that the protocol, if initiated, is precautionary. It's not a disciplinary measure. So what happens is the chairperson, if the protocol has been initiated, meets with the employee in question, tells them about the fact of the allegation, number one, tells them, number two, the nature of the allegation, and giving them details of it in writing if need be. And thirdly, providing them with details of whether or not the matter has been reported to TUSLA, and providing them with a copy of the TUSLA referral form if that has indeed been submitted. So the chairperson then informs the employee in the steps that I've set out, makes a record of the meeting for the child protection file, and just to bear in mind for ETB national schools, just to substitute the chief executive in that situation for the chairperson.
Thanks for that, Edel, and I'm going to come back to you later on just in relation to the disciplinary issues. Paul, Edel has talked about putting the protocol into action, as it were. It's almost as if the school is taking a breather for a couple of days to get their heads around things, and she did say it's precautionary rather than disciplinary. But this comes back to you. Once it's in place, we have to move on. And how do you advise boards then? Can you take it from here, as it were?
Yeah, and that's the thing, David. So that the protocol, as Edel outlined, is an immediate step in terms of when something comes to light. And then the board has to, as you say, they take stock, and they have to then determine what the next stage of action is. And, you know, we would say, and this is not us touting for business, but we do say you should, and the procedures say you should go out and seek legal advice in relation to what you're going to do next, because as we've said earlier on, there are balancing concerns here, primarily safety of the children within the school. But then if you're going to deal with an allegation against a member of staff, that member of staff has certain rights in relation to those allegations as well, and those have to be given credence to as well. So the ongoing arrangements, and the decision has to be made whether or not you're going to put the employee on administrative leave. That's a decision that can only be taken by the employer, the Board of Management. There are then steps in relation to advising TUSLA of that decision, making arrangements with the department for a substitute teacher in light of that decision. And also then, if you're going to put a member of staff on administrative leave pending further investigation of the matter, there has to be a basis for doing that, and you have to give the member of staff an opportunity to have a comment or make a submission to the board in relation to that proposal to put them on administrative leave. And that all arises from High Court decisions in relation to, we'd see the second Riley and Bank of Ireland, which kind of changed the law in relation to suspension / administrative leave, whatever term you want to use for it, where you are placing somebody out of the workplace as a precautionary measure in order to allow an investigation to take place. And there are a number of bases which the court laid out on the slide there in relation to why you might be able to do that in a way that's legally robust. And that's what you have to give consideration to. And I would say prudently you should document as well, this is exactly why we're taking this decision to put this employee on administrative leave. And then also to bear in mind that as part of that decision, there will be the possibility that there is a TUSLA assessment going on. There may be a Garda investigation involved as well, depending on the nature of the allegation. And you're going to have to balance the considerations of the board as employer, moving in the interaction between those two other processes, without allowing either of those two other agencies to override your overarching responsibility as an employer to the member of staff who's in your employment. So that is an area again where I think ongoing advice is worthwhile, and to, on an ongoing basis, revisit the decision to put the staff member on administrative leave, to, you know, maintain contact with both the member of staff, but also maintain contact with TUSLA and the Gardaí if required, in order to update yourself as employers to where are they in their process, and is our decision to put the employee on administrative leave still valid in the context of how long it's taking, if we've done it at the request of TUSLA to allow them to complete their assessment, where are we now in terms of timescale, and is that still a valid decision? So there are a lot of moving parts in that administrative leave decision-making process, and the ground shifts as you move along through the process. So I think it's something that boards of management need to be very alive to. I think it's appropriate that they take good advice in relation to that and revisit the decision as they move along. And I think there's a link there to an article on our website in relation to a scenario that might be useful for people to have a read of as well in light of that.
And Paul,
David,
sorry,
of course. I just wanted to share, I suppose, one case that our colleague Liam Reardon, who many of the schools will know, was dealing with fairly recently. And Liam is fighting the good fight in the Labour Court today, so he can't be with us for a school. But this was a case where TUSLA approached the school to indicate that they had a child protection concern or complaint relating to a school principal. And the school, the Board of Management or chairperson of the Board of Management, quite understandably said, well, can you tell us what it is? And they said, no, well, we can't tell you what it is because you're technically a third party, quote unquote, and we can't share information with a third party. So Liam looked up the procedures and found that the actual procedures do provide that TUSLA are not in a position to, are not authorized to share information with a third party unless they have a real risk or a real concern about a child protection issue. So Liam advised the Board of Management, well, go back to TUSLA and say to them, well, clearly you have a real risk or a real concern here, or you don't have a real risk or a real concern. And basically put it up to TUSLA to either share the information on the basis that they had a real risk or not. And I'd say in this particular case, TUSLA backed down completely and said that they didn't have a real risk. And the Board of Management said, fine. The Board of Management, by the way, didn't have a real risk, a real concern either. And other measures, safety, protective measures were put in place, and the principal continued on with principal's work and all was fine. So just, it's a complex and nuanced issue, and one which has to be looked at on a case-by-case basis.
so thanks to Paul and Ian for sharing those particular cases there. I'm going to now move back to Edel. And Edel, I suppose I'm just trying to draw your thoughts as a practitioner and as an advisor to schools in relation to child protection, and indeed of the rest of the team. These are nuggets you have taken and put together for us. Would you like to just...
Yes, David, just in terms of how and in what way we can support schools and boards of management in terms of dealing with these particular issues. And as Paul quite rightly said, you know, it isn't a case of us looking for work in terms of advices that we can provide for this. The procedures themselves explicitly state that legal advice should always be taken in relation to any proposed actions involving an employee. So with that in mind, and just in terms of how and in what way we can support a school, due process needs to be provided to the employee in terms of any allegation and in any disciplinary procedure that's been invoked involving the employee. And so we can advise a school in terms of how and in what way that should be provided. So, you know, natural justice, fair procedures, the right to be heard, employment legislation, how and in what way that might impact on the school's actions in terms of dealing with the issue with the employee, the disciplinary procedures themselves. We can offer the insight of our experience in terms of how the school might address the issue, as in, you know, if the principal or or albeit the chairperson determines that these issues should be addressed under stage 3, we can of course give our tuppence worth in terms of whether or not we agree with that decision being taken. Obviously, the final decision is a matter for the board, but that's how just one way in which we can support the school. Also, in terms of TUSLA engagement, the procedures themselves talk about the need for the school to engage with TUSLA and/or the Gardaí where relevant. So what we would advise the school to do is, if, for instance, a referral is made and TUSLA want a referral on a child protection issue, then we would always advise the school and the DLP, most often than not, to write to TUSLA and to look for updates in terms of how their assessment is progressing, and look for an update in early course. And we'd recommend that happen in writing in the first instance, maybe by a follow-up phone call too. But it's just to demonstrate, the school's duty of care, as Ian was talking about, the kind of 2 hats that the school wears: the duty of care to the employee to make sure that the matter is dealt with expediently, but also because the school has its second procedure potentially to address with the employee, that is the disciplinary procedure potentially with regard to the allegations. So that's something to be borne in mind as well in terms of how and in what way we can assist the board.
And Edel, I think the reassurance what we would take from what you're saying, and Paul, indeed Ian, once we go into the employment realm, as it were, legal advice is necessary. So you're not on your own as school leaders.
Exactly.
And take that assurance away. Paul, just a quick over to you from Edel there. She mentioned a board of management investigation. Investigations can be fraught in the workplace. You've considerable experience of advising boards and indeed employers in relation to investigations. Just a few quick thoughts on that, do's and don'ts.
Yeah, David, I think, I suppose there's one takeaway in terms of investigations, and where we would see, where I've certainly seen issues arising, is in terms of delay, which can often be an issue in terms of these types of allegations, because you may have external processes going on where you've, a principal or a board of management has been told by TUSLA, listen, hold off, don't do anything until we're finished our business, or the Gardaí might say to you, particularly depending on the type of allegation, look, don't do anything for a while. And if you don't follow up and you don't kind of keep in touch, as Edel has said, and if you don't keep your mind on it, it's very easy for time to lapse, and the next thing you know, you're 12 and perhaps 18 months and you have a teacher out on admin leave for that length of time, and it can be very difficult then to actually progress and conclude an investigation and conclude a disciplinary process. So I think, if I were to say anything to people today, would be, look, stay on top of these things. Don't be waiting for the letter from the employee or from the letter from the employee solicitor if things have got to that stage. Make a plan as to how you're going to deal with this and the touch points you're going to have with both the external agencies and with the employee, and your own considerations as to, look, can we progress this? Can we deal with this as an employer and progress our investigation? And I think that is one of the number one areas where I see problems with investigations, is that area of delay. So if you got on top of that, you'd be well on the way to having it dealt with.
Thanks for that, Paul. Thank you. And finally, just as we come to the end of our webinar, I know that Ian and Anya want to speak just about historical abuse complaints that come to schools. So over to Ian, Agus, Anya.
Yeah, thanks, David. Sorry, very few comments on this, but just to alert, because we have seen, an increase in historical abuse complaints coming into national schools. That's probably because of a number of sort of exposed abuse cases in schools, and it tends to give a voice to people who maybe haven't spoken up for a long number of years. So I'm just going to ask, Anya and I have been working on a number of the cases recently. I'm just going to ask Anya maybe to give a summary of how these kind of complaints can arrive in a school. Anya.
Yeah, so they can come into the school from a number of different sources. I think that for the most part, they come directly from a former student or from a former student solicitor. When you'll get a solicitor's letter, the board of management, the chairperson will get that letter. But we have seen an increase recently in complaints arriving from sources such as the Gardaí, who are, investigating a complaint made to them, TUSLA, the department, and sometimes the media. And another kind of prevalent one is, social media and rumors that pop up. So that's another source, definitely.
And one of the things that we've been sort of often advising on is, what is the immediate response? Now, obviously, this is a child protection webinar, so the immediate response is child protection, as you would expect. But we're kind of more focusing on a situation where perhaps the subject of the complaint is no longer employed in the school, because obviously if the subject is with them, then the child protection protocols jump into place immediately. So presuming that there isn't any immediate child protection concern in the school, the kind of guidance that we would give is, one, take advice, because you need advice. These are awkward situations. Report the complaint to TUSLA, because it may fit in with a wider case that TUSLA is dealing with, about which you know nothing. Inform your insurers, because if you're on notice of a complaint, you're on notice of a possible claim. Indeed, as Anya said, that the initial notification may involve a solicitor's letter. Don't respond to a solicitor's letter without advice. I mean, that goes without saying. And then you need to think about what sort of a response you're going to give to the complainant. And I mean, Anya's going to talk about this in a moment, but like an awful lot of people think, the complainant wants an admission, wants me to admit that all this complaint is true. Well, how could you possibly do that when you mightn't even have been in the school at the time of the complaint? So, take advice, because there is good practice around here which can be shared with you by way of a support. And one issue that we often advise upon is offering the complainant a meeting, and that's something that Anya and I have spoken about recently. Anya?
Yeah, exactly. In our experience, not all complainants do want to make, a legal claim, and it's just to kind of offer that support and a listening ear, and just, it's by someone, to offer that listening ear by someone in the school. Now we do appreciate that it is, it's a very difficult situation, and some principals or, perhaps chairpersons of board of management might be very nervous about attending such a meeting. We have advised a number of principals about how to handle such meetings, and the outcome for the most part has been very positive. So that's just one option that definitely should be considered in this context.
Okay, thanks for that. And that's a very interesting take on that, offering a meeting and to be a listening, to fulfill a listening role there. Ian, we've come to the end of the webinar now, and just
yeah, David, time is short, so I won't go spend any time on these takeaways. Anybody who's attended previous webinars will be sick of us saying about reading policies and procedures. So I mean, the first one speaks for itself, but the other ones we've kind of touched on, and I just leave you with the slide, just as a kind of an easy checklist of things to bear in mind. Thanks, David.
Thank you, Ian. And just to say that anybody who submitted questions, we've tried to build the questions into the actual presentation themselves. Ian is going to send you a link shortly of a recording and the slides. Also, you'll have an opportunity to do an evaluation on us. Now, this might be like Christmas, turkeys voting for Christmas, but please do put down your viewpoints, and particularly we'd be interested in what you'd like for future webinar content in particular. So we would like to thank you for your attendance, and on behalf of Edel, Paul, Ian, Anya, and indeed Liam Reardon and Catherine Kelly, who are not with us but who've contributed to this webinar, we want to wish you well over the next month, the craziest month of the year, the month of June, and to say that there are some excellent resources to be available on the websites of the CPSMA and of course the IPPN also. And if we can help you in any possible way with queries in relation to child protection or indeed any other area of law, please feel free to contact us. So all the best. We hope you have a great summer when you do get around to it. So thank you. Agus Lán.